Hi, thanks for joining me. This is Cheryl Sattler. I am the Education Advocate in the Tallahassee Office of Legal Services of North Florida, and this module is the first one on students with disabilities. So we'll talk about basic rights, including eligibility, parental role, and timelines. Please note that this presentation is based on federal and state statutes, regs, and case law as of June 2023. The law does change, so please make sure that you are checking for updates. This presentation provides legal information, not legal advice. For case-specific advice, please contact Stephanie Johnson, Senior Managing Attorney at the Tallahassee office, or steph@lsnf.org. All this slide is here for is to give you a place to go when you need the legal authority. So we're looking today at the Individuals with Disabilities Education Act, as well as Florida statutes and Florida rules. Wanted to just hit a couple of definitions before we get started. So special education is specially designed instruction provided at no cost to parents to meet the unique needs of a child with a disability. There are lots of different terms that refer to these students. In federal law, they talk about SWD, students with disabilities. So you'll see that shortcut or acronym on charts and graphs and all sorts of data. In Florida, we call these students ESC students, or students receiving exceptional student education. And just as a side note, Florida includes gifted students within the group of students called ESC. So there are a lot of steps in the process. ESC or special education is a cyclical process, so there's always something happening. In case you don't have a full cup of coffee, don't worry. We are not going to talk about all of them right now, but I wanted just to lay them out so that you could see where we are in the grand scheme of things. So it starts with identification, evaluation of students to see if indeed they do qualify, and that is called an eligibility determination. Once a child is determined eligible, a team develops a plan for that kiddo. A parent must consent for services. There is an annual review, and of course, there's a reevaluation that is periodic, and the IEP is only for a year, so we're always sort of talking about 1 12-month period. Sometimes that crosses school years. Don't be confused by that. Okay, so it all starts with something called child find. This is one of those rare moments where a term actually makes sense in the federal world. And what that is a state mandate to locate all children from birth through 22 who may need those specialized educational services. So this is an affirmative duty. States have to actually go out and look. And once they find kids that might qualify, they have to ask for permission to evaluate them. And so we run into this failure of child find, which is actionable, and you can get things like compensatory education or reimbursement for private school placement for a failure of child find. And we run into this a lot in the disciplinary context, where you've got kids who have been displaying all kinds of extreme behaviors, and because it's not academic, schools just don't kind of click in on, hey, maybe this is a special education issue. We also run into it where we have young children who maybe aren't formally tested, so they don't get a lot of state testing, or kids where, schools are just kind of, well, they'll get it eventually, and let's put them through some more interventions. So you always have to look back in time and say, when did this child start exhibiting this issue or these behaviors? In Florida, because why make it easy, they actually have 2 agencies in charge of these responsibilities for child find. So for very young children, the responsibility rests with the Department of Health, and it has a specific program called Early Steps. For children 4 to 22, that responsibility rests with the Department of Education. However, because again, why make it easy? There's a lot of overlap. So you may find children who are identified by the Department of Health and their folks who actually are served by schools and vice versa. So it's a pretty fluid system. And by the way, in case you want to see how Florida is doing on Part C, which is the little ones, there is a fairly current monitoring report, and the punchline is not very well. Okay, so IDEA, like all federal laws, is made up of lots of different parts or titles or chapters. In IDEA, we have parts, and the part that covers young children is called Part C. So this is early childhood, birth to 3. And primarily there, we're looking at developmental delay. So this is pretty broad. It has nothing really to do with education yet. So there's really 2 ways that you are found eligible. Either you have one of these listed established conditions that we know medically places children at risk of developmental delay. Some of these you'll recognize: autism spectrum disorder, neurological disorder, but we also have low birth weight babies. And, actually, this is just so medical that I don't even get into it. What is more typical in our world is the second path, which is when there are concerns about potential developmental delay, when a child is failing to thrive, failing to meet developmental milestones. And always under IDEA, we're looking at comprehensive evaluation. So even though you might say, I think this child has a hearing problem, we're going to err on the side of caution and do a comprehensive, a broad sweep assessment. And so we're looking across 6 domains. And I've not only spelled them out, but given you some examples because, frankly, I don't really think about what adaptive development is, but it's important, and it's one of the areas that kids struggle with. So we have physical, cognitive, gross and fine motor skills, communication, social and emotional, and adaptive development. So typically what happens in terms of child find for young babies is it's either a parent who notices that the child is just not developing maybe the same as other children in this adult's life, maybe differently than a sibling, or a pediatrician or a hospital, a physician. They say, because we're constantly measuring young children against, typicality. And we say, what, this child is really at, the 10th percentile for something, and that's not a good sign. And of course, another way, and this happens in our world a lot, is that it's linked to a DCF investigation. So we have a child protection investigator who finds a child and, the child is 4 and not speaking, or the child is 5 and not toilet trained. All of these are raising questions about potential developmental delay. So speaking of abused and neglected kids, there's actually a specific provision in the law that even if a child does not necessarily meet eligibility criteria under those tests, there are a couple of conditions that they have to get services. So the first is if a child has been involved in a substantiated case of child abuse or neglect, or identified as being directly affected by illegal substance abuse or withdrawal symptoms resulting from prenatal drug exposure, and for whom a developmental delay is indicated. So these are our fentanyl babies, our crack babies, our meth babies, as well as kids who are in substantiated cases. And then if the child is not removed from the home, if the child has been found to be able to stay in the home, maybe with a safety plan, and hasn't gotten additional services by DCF, the school district has to accept that referral for the child, because basically it's it's a pretty good bet that that child needs some support. So ordinarily, without those exceptions, once a child has been identified, we think maybe we're going to flag this child. Then they go through this evaluation for eligibility. And again, they test that child in all of the domains that may be potentially at issue. And, when you think about test, you probably think about, I don't know, sitting at a desk and filling out a bubble sheet, but this is not that kind of testing. This is, a psychiatrist or a psychologist or another qualified person interacting with the child, seeing how they grab things, seeing whether they make eye contact. So just remember that testing is very broad. There are specific rules for evaluation, and I give you these because not that you need to know them, but when you find a child who is not found eligible, you want to maybe double check and make sure that the evaluation was really appropriate. So did it have a standardized evaluation instrument? Did they document the child's history? Did they actually look at each one of those areas? Did they talk to other information sources? And that can include attorneys. And finally, did they actually review medical, educational, or other records? So this comes up a lot with foster kids because the evaluator may not have access to family members. There may not be very many medical, educational, or other records. And so all of that just sort of should give you pause and say, all right, how can we flesh out this child's information in a way that would support their eligibility if we really think they need it? So once a baby is found eligible, so 0 to 3, again, this is not really about education. This is about development. So they get an individualized family service plan, which we call an IFSIP, just because I like to sound like I lisp, apparently. And if you notice from this slide, it's very home and family centered, very naturalistic. The family, the service coordinator, and at least 2 professionals that provide services to the child develop this plan. Services are provided wherever the child is. That's childcare. If it's well, it's too early for pre-K. If it's at the home, if it's at the park, very much we are not disrupting this child's natural environment. And the plan, the services are very family centered. So I have visited homes where they had children in early steps and they have, routines to practice. And it might be greeting people. It might be, showing a parent something. It might be retrieving something. So they're constantly working to reinforce skills at home. Every process under IDEA has a timeline. And this is something that you want to use to your advantage. You want to make sure people are very timeline sensitive under IDEA. They don't want to get dinged for this. A timeline violation on its own probably won't get you much, but you can add it to the pile of things when you are trying to get something for your client. So for a young child, you have 7 calendar days. Oh, and by the way, under IDEA, there are calendar days, there are school days, there are not school holiday days. So you always have to make sure that you know which kind of day we're talking about. So 7 days from identification to referral, 5 days from referral to parent contact, and then what seems like a pretty long time, 45 calendar days from referral to evaluation. Honestly, I'm not sure why it's that long. I think sometimes it's just very difficult for, particularly at certain times of the year, to get professionals who are available to do this kind of intensive screening. So let's move on to babies who are a little bit older, 3 to 9. So now we're under IDEA Part B. I don't know, celebrate. we can still look at developmental delay. So there's some overlap here. And this is actually valid in Florida until age 9 or the end of second grade. And that state statute just changed in 2022. So federal law actually gives states flexibility. States can choose to end that criterion at 5 or at 9 or anywhere in between. So it used to be at 5 and now it's at 9. So here we are starting to talk about education itself. So the school district is the entry point. If a student's found eligible, they actually get their own plan, and it is about education. So if you're 3 to 9, you get services in a voluntary pre-K specialized instructional services program, and those are typically called VPK SIS or pre-K D. So that's pre-K disabled. And that's the more typical term that you hear in a school district. So how do we find these kiddos? Well, we are looking a lot more at education now. And if you've been to a kindergarten lately or a pre-K lately, you know, I spend a lot more time napping than these kids do. They are doing pre-literacy. They are doing all kinds of things that are much more academically focused. So we start to look at educational data, and it can be response to intervention data. Response to intervention is literally what it sounds like. How does a child respond when they are given additional support and more intensive intervention? And that's really what schools are taught to do, is if a child doesn't succeed at what every child is getting in that classroom, they're supposed to get something more, and you're supposed to track how that works. They could be screened through what we call Fiddlers. It's a Florida Diagnostic and Learning Resources System. Fiddlers is funded by the State Department of Education, and it does a lot of child find. Or a parent starts to worry about, you know, my child is really frustrated and doesn't seem to be getting this stuff. And so I want you to evaluate my child. So either the school or the parent can actually initiate the process. If the school wants to test a child, and frankly, it is a kind of a mixed bag, depends very much on the school, they will notify the parent that they think that their child may qualify and ask for consent to evaluate the child. If the parent initiates it, it goes like this. The parent in writing says, I think my child has an issue. I want you to evaluate him. And what happens a lot, and why I've said best practices is signed and dated writing, is that a parent will call the school, or they will make a comment in passing to the teacher or to the principal, and they'll say, hey, you know, I think my kid really needs, you know, they may need special ed. They may need, you know, some more support. And the principal forgets or the teacher forgets, and then the parent gets frustrated because nothing happens. So if you have a signed and dated writing, then you have a way of holding the school accountable. And if you keep a copy, even better. I like to tell people that when they make this request, they should ask for a receipt. And oftentimes that's just somebody will make a photocopy of the parent's letter and write, you know, the time and the date and who received it. Again, just trying to build that trail to hold schools and districts accountable. And all this is on slide 20 is what goes in that letter, just putting that out there for you to have. Okay, so let's talk about RTI for a second again. So RTI and MTSS are the same thing, different names because, hey, that's fun, right? And so schools are under the mistaken impression that they have to exhaust their options before referring a child for evaluation. And you sort of see the point there. You really want to make sure that the child is getting all the services that they need in the regular classroom. But that can also take a long time. Some schools are really efficient and they'll do it for 9 weeks and they'll try 3 different interventions and they will document that, and that's great. And some schools will use that process for 2 or 3 years. And that definitely delays things. We know that earlier services are better. And so the myth that schools must use RTI or MTSS or what's called a tier 3 intervention. So RTI and MTSS both look like a triangle. And so at the bottom, you have all students. In the middle, you have some students. And at the very tippy top of that triangle, you have what's called tier 3 students who need intense interventions. So it's a myth, though. They do not have to go through this process. And if they tell you this, you need to interrupt that because, like I said, it can really delay things. As with other parts of IDEA, we have timelines. So you have 30 calendar days from the notification to getting that parent consent, and then 60 school days to evaluate the child. I got to say, 60 school days is a long time. And if they run into summer break, it gets even longer. If a child is not in school, those days don't count against them. So personally, I spend a lot of time with calendars counting days. And so once you put that request in or work with that parent to put that request in, you want to mark on your calendar, what's 60 days. And you hope that they don't take all that 60 because, that's not the end of the process, right? All right, so let's talk for a second about eligibility from 4 to 22, because now we've moved from, well, again, except for those kids who have developmental delay, okay, so possibly through age 9, we've really moved to a disability that impacts education. So there's 13 categories. These are all defined in state rule. There are specific criteria for each one of these. So, and you can see what they are there. If you happen to be looking at an IEP from another state, some of them like to rename things or combine things. Just that's the way it is. Okay, so again, the evaluation is comprehensive. So, for example, if you have a child who is having behavior issues, who also maybe they have a traumatic brain injury, maybe they have some sort of orthopedic impairment, and they're having problems with schoolwork, you may be asking them to be evaluated in 3 or 4 different categories. So a child can have more than one category. There's a primary, there can be a secondary and a tertiary. So you're really wanting that initial evaluation plan to look pretty robust, right? You want a variety of assessment tools. You want functional data, developmental data, academic data. You want to make sure that the school is talking to the parent or the legal guardian. So that can include DCF staff. It can include foster parents. Just wanted a side note. So just because a kid is tested does not mean that parent consent is required. Their kids are tested all the time in school, right? They have progress monitoring tests, they have state assessments, they have quizzes. Anything that all students get, no parent consent is required. But these special, pretty in-depth, sometimes involving psychological evaluations, definitely you need assigned parent consent. So a regular assessment can include things like vision and hearing screening. You may remember being screened for scoliosis as a child in PE. So again, anything that the school does for all or most kids, not looking for consent. And here's something that sometimes parents don't understand. So just because your child is autistic, just because your child has a traumatic brain injury, just because your child is blind, does not mean that they're eligible for special educational services. So this is a two-pronged test. You must have the disability, and that disability must impede the child's ability to learn. And so the typical questions they're asking here are there special learning needs? Are there special behavioral needs? How about assistive technology? What about related services or supplementary aids? And that related services category is quite broad. So we'll talk about that later. And just to beat a dead horse here, the medical, and parents have these, here is my child's diagnosis from his pediatrician that says he has ADHD. Okay. So that diagnosis alone is not sufficient. It has to manifest in developmental or functional impairment that make the child require those special services. However, please note that if a child has a disability, but that child does not qualify under IDEA, there is kind of a backup law called the Vocational Rehabilitation Act. So we call it Section 504, and we will talk about Section 504 later. So what is your role as an attorney? Well, not every parent or foster parent or caregiver is really going to know about special ed, or else they're going to think, oh, that's for kids who are really, really. But as an advocate, you really should look at special education when a child is consistently showing up with bad grades. I'm talking straight F's, D's, every report card says, when the child has consistently low test scores, when you can't understand them talking to you, the child can't follow directions. They really can't focus. They're really frustrated with schoolwork. They become truant, so they're frequently absent. I was looking at a kid's absence record yesterday, and he was absent. I think he was there for about 6 of the school days. That's a problem. Also, and this is really important, when a child is frequently disciplined or suspended for similar things, you want to look into this. So there's this kind of weird dividing line under special education for emotional disturbance versus disability. And I just want to put this out there because when we have kids in foster care, a lot of them bring with them lots of trauma. And IDEA actually draws a line between what they call an emotional or behavioral disturbance and social maladjustment. So naturally, socially maladjusted is not defined because, that would be easy. So here is the key. The school is going to say this child intended to beat up another kid, intended to run away, whatever. And your argument is always that it was not volitional, that child has impulse control issues, that child, didn't understand what was going on. So you're always arguing, yes, this is part of a disability, because if it's part of a disability, they get services. If it's an social maladjustment issue, they're not served. So there is, however, and I hope that it never gets this intense for you, but just to put it out there, you can have comorbidity, right? You can have both things. So if you are just socially maladjusted, you don't get special ed. But if you have an emotional disability and you're socially maladjusted, you can get special ed services. I have a quadrant chart that I have not been able to figure out how to cut and paste. So hopefully I'll do that one day. And the following slides I'm not going to go over. They are just background for you if you find yourself in this situation. So ways to make your argument: social relationships, interpersonal dynamics, educational performance. Okay, enough on that. So let's talk about a couple of key concepts. One of the key concepts in IDEA is called procedural safeguards. Now, if you wrote this part of the law, you would probably just call this due process. So parents have specific rights under IDEA, and those rights have to be written down. Florida has a really long, complicated pamphlet that it gives out. I would love to rewrite that in actual English, but I don't think I'm going to get that opportunity. So just this slide just says when they have to get them, but you should know what they are. And so we're going to talk about them for a second. So one of the procedural safeguards is the right to have written notice. When a team is having an IEP meeting, before a student is evaluated, before a student's placement is changed, and that's a huge thing. We'll talk about it later. Parents have the right to participate when the team is determining whether the child is eligible for services, when the IEP is developed or reviewed, and when there are decisions made about placement or services. The parent has the absolute fundamental right to give, not give, or to withdraw their consent at any time. A parent also has a right to receive what's called an independent educational assessment. We generally call that an IEE because it's independent educational evaluation. But that's if the parent disagrees with the district's assessment, and that is something a district has to pay for. So that can be an argument, tends to be a little contentious. There are procedures to protect the rights of the child when the parent is unknown, cannot be located, or is a ward of the state. And finally, the parent has an absolute right to present a complaint. And we will spend significant time on that in a different module. All right, another key concept is prior written notice. And that's one of the procedural safeguards, right? So notice, they just call it PWN, prior written notice. And anything yes or no that the parent, that the school wants to do has to be communicated to the parent. And it has to tell them what they're proposing to do, why they're proposing to do it, and the parent's rights. Something that we see happen a lot is that this is just presented in English. We have parents who are illiterate or functionally illiterate. We have parents who speak many languages. And this is not something that can get skipped. So, and you can see there are specific situations where this kicks in. And so when you are looking for things to add to your pile of what the school did wrong, you want to look for prior written notice. And you want to make sure that not only was there notice, but it was sent and that it was complete. And these are the things that it has to have, right? The proposed or refused action, why, descriptions, the procedural safeguards notice. They have to be able to, the parents have to be sent to some other source because these notices are crazy complicated sometimes. They have to be given information on other things that the school thought about and any other factors. So it can be, like I said, a long document, and you can see why it's really important that it be readable and understandable by parents. Just wanted to put this out here. These are the key events that you're looking for prior written notice. Evaluation, when we start services, when we put a child in access points curriculum or alternate assessment. That is a specific special ed curriculum, typically for children who are intellectually disabled. Alternate assessment is a test that is different than the test that other kids take for progression grade to grade or graduation. When you defer graduation, so deferring graduation means I can get services through age 22, but the only way to access those services once I hit graduation age is to defer graduation. So that is an important decision. When a child is placed in a special education center or a center school, and that is a school that only has other kids with special educational needs there. if a parent does not grant consent, the district can, but is not required to, go to mediation or file for due process to get the parent's consent. It's fairly unusual for a district to try to do this. It's easier for them just not to serve the child than it is for them to take the parent to court. However, it does happen. Okay, let's talk a second about parents, because parents are, I think it's very clear, a huge part of IDEA, and things don't happen in IDEA without parents. So, for example, and we've talked about some of these, you have the right to refer, you have the right to refuse evaluation or services, you have the right to participate, and you have the right to information. Okay, so let's talk about who is a parent, because boy, families are complicated. So a parent can be a biological or adoptive parent. Great. It can be a foster parent. And a foster parent is okay as a parent under IDEA in Florida if they're a regular foster parent, a family foster parent. However, if they're a therapeutic foster parent or group home staff, they are not allowed to serve as the parent. You can have a guardian, and sometimes that guardian just holds a limited power of attorney that is authorized to make educational decisions. So this is what happens in Florida. DCF thinks, I am the child's guardian, and they're not. It's specifically illegal. DCF staff cannot act as a parent because they have an inherent conflict of interest, right? They are another serving agency, and they are not determined to have the child's best interest in mind, and they also are not educational experts. It can also be any other grown-up, right? You can have a grandparent, a step-parent, another relative, somebody the kid lives with, somebody who's responsible for their child's welfare, or, and this is the big one for students in foster care, you can have an educational surrogate. So this is a person who is appointed either by the court or by the school district to serve in that parent role. So in Florida, it's required that the first person to be considered is the child's guardian ad litem, if they have one. If they don't have one, you move on to another adult who has the knowledge and skills that are acquired by completing training. It's a very brief training. Unfortunately, this is something that is not standard practice in many school districts. So you have a child, the DCF tries to act as the parent, and then the child is moved elsewhere. They get a new case manager, and there's very little continuity. No one knows, the child's educational background. And frankly, school districts are not, they are not experts on foster care, right? They have no idea that foster care is like a range of things. So they are not likely to realize, hey, this kid's in a group home, they need a surrogate parent. So you are often in the place where you are saying to the school district, this child needs a surrogate. Okay, so surrogate requirements are not onerous. You have to be over 18. You can't be employed by the school district or any other agency that's involved with the child. You can't have personal or professional conflicts of interest. You need to, know your stuff, and you do have to be trained. So when you're working with kids in foster care and things are coming up educationally, remind the district the kid needs a surrogate when there's been a TPR, right? The parental rights are terminated. The parent is absent or missing or does not engage. When you have a therapeutic foster parent or group home staff, or somebody who is a foster parent is not willing, doesn't feel capable of doing this role. And when a child is highly mobile, this becomes really, really important. So as an advocate, please know a surrogate is a parent under IDEA. So a surrogate has greater rights than you do as an attorney. because they have decision-making authority where you as an attorney can only come in and challenge things. You generally should ensure that a motion is filed with the court naming the surrogate, inform the district in writing, and ask, this is really important, ask that the surrogate's contact information be put on the IEP. Because what happens is that they move a child and the child has an IEP. And if that information is not right there, nobody knows that there's a surrogate. And then, either they appoint another surrogate or they spend, weeks trying to track down the surrogate. This has happened to us. So you just want to make it easy. And just as a reminder, a surrogate is one of the procedural safeguards that's required under law. And the district has to appoint that surrogate within 30 days of a determination that a surrogate is needed. Now, that's their determination, not your determination, but obviously you can push that. All right, so we're almost done. Just want to talk about a couple more key concepts and then let you go. So FAPE, everybody talks about FAPE. And it sounds like fate, it's not. So FAPE is a free appropriate public education. So it's basically shorthand for special ed. And you see, again, provided public expense, publicly supervised, no charge to the parent. You want the child to be able to meet the state standards. It includes pre-K, elementary, secondary, and what makes it appropriate is that education is provided in conformity with the IEP. All right, going to hit another key concept here, stay put. And this happens when there's a dispute and the school wants to move a kid and the parent or the surrogate thinks the kid should stay right where they are. So school districts cannot act on their own. And I hope that's been clear throughout this, that parents need to consent to major activities. Well, moving a kid is a major activity. And so stay put is most useful when a parent is happy with the placement and, they may have taken the district to court to get more services or on other grounds, but, they don't want to necessarily move their child. And of course, if they prevail at a due process hearing, they want to stay put. So stay put can serve as a catalyst for getting what you want. So we're going to talk about that in future modules. Just want to put it in the back of your head. Hey, there's this thing called stay put. And P.S., it doesn't actually apply in disciplinary cases, which tends to be where you really need it. But, all right, finally, just know that rates differ between public and private schools. This is a huge issue with vouchers in Florida. So if a parent enrolls a child in private school, they have no right to individual services. They don't get an IEP. They don't necessarily get served at all. School districts have to set aside what's called an equitable share for sort of a pool of funds for services to private school students. But, flip a coin whether the kid that you're interested in actually gets services. So that's a big deal. All right, so I am done talking at you. There are some general resources on this slide that I hope will be helpful to you. And hopefully you will tune back in for some more on special education.